Hello, everyone, and welcome to today's webinar presentation, the DOL's Final Overtime Rule, What Employers Need to Know. As you know, the Department of Labor's final rule on overtime regulations under the FLSA will take effect July 1st, 2024. Today's presentation will walk you through the key takeaways that employers need to know in order to properly prepare for these changes. But before we get further into today's topic, I would like to take a moment to introduce myself and my organization. My name is Zielinski, and I'm the Marketing Director of ComplianceHR. You may recognize my name from the email invitations you received for today's event. To prevent a few popular questions from entering the Q&A box, I would like to let you all know that this presentation will be recorded and emailed to you if you are registered for this event. So please keep an eye on your inbox for an email from ComplianceHR webinars. Now, a bit about ComplianceHR for anyone who may be unfamiliar. ComplianceHR is a joint venture between two incredible and innovative organizations, the AI technology company Neota and the law firm Littler. ComplianceHR delivers expert employment law guidance in a fraction of the time. Our goal is to simplify the complexity of employment law, something we will learn a lot about during today's presentation. To achieve that goal, ComplianceHR offers a suite of technology solutions around critical HR compliance topics, like employee overtime, independent contractor misclassification, employee handbooks, onboarding, and leave, among many others. Today, I would like to briefly introduce you to Navigator Overtime. Navigator Overtime, or Navigator OT, helps you quickly and compliantly determine the proper exemption status for an employee position with an easy-to-use digital questionnaire that captures your specific fact pattern, actionable risk assessments driven by expert analysis and instant actionable guidance and a customized report. You can lower the risk of misclassification. If you're interested in learning more, a survey will pop up on your screen. You may have to exit full screen mode to see it. If you would like to receive a complimentary demo of the Navigator suite, simply answer yes, and I will pass your contact information on to our team of experts to have a deeper conversation with you about your compliance strategy and how we can help to support it. In addition to our demonstration of solutions, you may be eligible to receive a free trial of our products so you can see precisely how much time and money they can save you. While the poll is running, I wanted to share a bit more about how the Navigator OT solution can support your organization as you prepare for the new overtime rule. With the simple questionnaire performing all applicable tests local to the position's jurisdiction and nationally, this solution can save you more than 90% of the time you would otherwise spend performing an employee overtime classification audit manually. So again, if you're interested in seeing these solutions, please select yes on the poll or click the link in the links panel. Now I have the pleasure of announcing today's webinar presenters, Jim Paretti and Alex MacDonald. Jim and Alex are both shareholders at Littler's Washington, D.C. office and members of the firm's Workplace Policy Institute, or WPI. Thank you both very much for your time today. Alex, I will pass it over to you.
All right, great. Well, thank you, Stephanie, and thank you, everybody, for jumping on to the webinar today. We've actually got quite a bit of material to get through, so I'm just, rather than spending a lot of time on an introduction, I'm going to go ahead and get started. Today, what we're talking about is changes to the quote-unquote white-collar exemptions. These are the executive, administrative, and professional exemptions. Most people on the call are probably familiar with these. We're going to do a quick overview of what they are anyway. Essentially, the FLSA requires all employers to pay all employees, with noted exceptions, overtime and the minimum wage. But among the noted exceptions are the folks who work in these defined executive, administrative, and professional capacities. Okay, that's not self-defining. What the statute doesn't tell us what that means. Instead, it says that they will be defined and delimited, which essentially means defined, from time to time by the Secretary of Labor. Well, how has the Secretary done that? So the Secretary uses 3 tests to determine whether any individual worker is an employee is a exempt employee or a non-exempt employee, meaning whether the person is eligible for overtime and the minimum wage. Those are the salary test, the salary basis test, and the duties test. The salary basis test essentially means that the person is not paid an hourly wage. Instead, he or she is paid a fixed amount regardless of the amount or quality of the work performed. So essentially, I agree with you ahead of time that you're going to receive X dollars per week, and you're going to get that regardless of how often you work, how long you work, and how good your work is. There are exceptions which can get us really into the weeds. We're not going to focus on that here because the rule that we're talking about did not change the salary basis test. That's the important thing to keep in mind. This is the same as it has always been. All right. The next one is the duties test. We've got the duties listed here. I think most people know intuitively what an executive, administrative, or professional employee is. This gets complicated. Every single one of these phrases is sort of been barnacled up over the years with a lot of judicial interpretation. We're not going to get into that here again because anybody who was doing executive, administrative, or professional duties as their primary duty before this rule is still doing them. Because the rule does not change anything about the duties test. Now here's where we actually get to the change. The third test that you have to look at when deciding whether somebody is exempt is the salary level test. And this is essentially how much money does the person get paid every week. It may seem strange at first to talk about salary levels when we're talking about exemptions in terms of duties, whether somebody is a professional employee, whether somebody is an administrative employee. But to make this make sense, you have to keep in mind the historical rationale for it. It was always supposed to be, as you can see from the quotes we have up here, a rule of thumb, a heuristic. The idea was that, at least in the 1930s, 1940s, when these rules were new, that the kind of duties we're talking about, exempt administrative, executive, and professional duties that require some discretion and judgment and high levels of skill and knowledge and training, supervising other employees, these are the kinds of things that only high-level employees were doing. So if somebody was being paid a pittance, a couple, very low salary, then that person was highly unlikely to be an exempt employee. So we could just screen them out and save our time doing the more complicated analyses under the salary basis test and the duties test for the employees who might actually be exempt. And that's illustrated by these quotes here. So we're looking for obviously non-exempt employees, people who are earning salaries that are so low that it's effectively disqualifying. That was the basis for the salary level test. And now we're going to go a little bit more into recent history, and I'm going to kick that over to Jim.
Sure. Thank you, Alex. And we're going to start, as we said, these exemptions have been in the FLSA since 1938 in some form or fashion. We will fast forward to realistically, it was in 2004, we sort of consider it to be like the contemporary development of the EAP exemption. What happened was in 2004, Department of Labor eliminated, they previously had two different tests that they'd use, a longer test and a shorter test, and depending which duties you were satisfying, the salary level varied. In 2004, the department said, no, we're going to streamline that. We're going to have one simple test. We're getting rid of the long and short. We're going to have one standard test with a standard number. And they adopted what they said it would be, sort of had the long test continued. They also, for the first time, created what's called the highly compensated employee exemption, or HCE. And they pegged that at $100,000. Now, we'll talk about how they got to that $455 a week, what that was based on. There was some math. I truly believe it may be apocryphal that when they were trying to come up with highly compensated employee, it's 2004, and someone said, yeah, six-figure salary. That sounds like a highly compensated. I think that 100,000 number was largely pulled out of thin air. There's not a whole lot supporting it. But in contrast, when they were looking at sort of how to pick that standard lower number, at the time, $455 a week, they looked at the 20th percentile of weekly earnings, full-time workers, in the lowest wage census region, which was the South, as well as in the retail industry. And they basically saying, if you fall in that bottom fifth, we're going to look at the 20% census range. If you fall below that 20%, you are, as Alex said, you are not making enough money no matter where you work to be considered an executive. It's an easy rule of thumb, sort of an easy screen. The historical screening test is sort of what they've called it. And that number, $455 a week, or about $23,600 a year, was in place from 2004 through 2016, when the Obama administration published a regulation that proposed to increase that overtime white-collar threshold using the 40th percentile of weekly earnings and moving it up from $455 a week to $913, almost $48,000 a year. Again, now instead of using the 20th, they're using the 40th. So saying if you fall, really more than a third of the workforce falls below that, that census range. And I put that 40% number up there because it does become significant as we talk about the new rule and challenges that are being lodged to the new rule. Other thing to note in 2016 was that for the first time, the department included an automatic escalator clause saying, okay, we're going to raise the number to here, and then every 3 years from now, it's going to automatically kick it up because, well, gee, it's, it takes a lot of effort to do this. We always say we're going to. It's a formal rulemaking, blah, blah. Lots of reasons why, oh, no, we're just going to set it and forget it. And again, that too is something that becomes important when we talk about where challenges to this rule might lie. Because, not surprisingly, in 2016, the final rule was challenged. Our firm, Littler Mendelson, brought that challenge on behalf of a coalition of business organizations. There was also a coalition of state attorneys general who brought a similar suit all down in Texas. We had a very good result. We got that rule first enjoined on a national basis and then ultimately struck down in its entirety. But I flag this because this is important as we think about what we should be doing, and Alex will talk a little bit about what we should be doing next. But back in 2016, the rule was scheduled to become effective on December 1st, 2016. We filed papers, we filed the complaint. We did not get an injunction until November 22nd, so only 8 days out. And what we found happened at the time, where you had lots of clients who I think were trying to be, good doobies, or said, I don't want to have to deal with this over Thanksgiving. They had made these adjustments, they'd made their changes, they'd instituted what they were going to do to comply in advance of that December 1st date so that they'd be ready for it. Then when the rule was enjoined, they found themselves in a position of saying, well, you really can't put the toothpaste back in the tube. If I told someone I'm raising their salary so that they meet this new exemption threshold, very difficult to say, nope, no backsies, just kidding. So I put that up there just because it was a similar situation to what we may face now, which is, deadlines are coming, but we do not know yet. There is still a chance that this rule will not go into effect. So that was in 2016. There was an appeal of that rule to the Fifth Circuit. Ultimately, when the administration changed, that appeal got withdrawn. And we flash forward to why did they exactly eliminate that $913 level, that $47,000? And what the court said at that time, which I think is very significant, is saying by setting that salary level so high, that 40% number, you were effectively reading the duties test, which is really the only specific thing in the statute. You were reading the duties test completely out of the statute. Whether you were exempt or non-exempt really didn't become about what was the work you were doing, not what you did. It was about how much you made. And that was never what the FLSA was intended to be. Congress didn't intend it to be that. And the court said by setting that threshold number, that 40% so high, you effectively went beyond the scope of what you're empowered to do under the statute, beyond the intent of Congress, and struck it down. What happens next? Another new administration, this time it's 2019. They formally rescind that rule, which the court had already vacated, and they raised the salary from around $23,500 up to where it currently sits as of today, $35,568 a year. They raised the highly compensated from $100 to $107. For the first time, they included the provision saying that up to 10% of the salary may be satisfied with a non-discretionary bonus or a commission. And I'll talk about that in a little bit because that can get pretty tricky pretty fast. I want to make sure people, walk away with the right takeaways here. But essentially, that's what they did in 2019. They upped it. And what number did they use? Well, again, having realized that, all right, 40% the court said was too high, they seem to historically been okay with 20%. In 2019, the department again used that 20% number, and that was, they looked at the lowest census region in the South, and they used what's come to be known as the 2004 methodology, using that 20th percentile, and that's where it sits as of today. Now the fun part, and what everybody tuned in for. It only took us 14 minutes to get there. The new rule. Well, the final rule was announced in April of this year, April 23rd. And this is interesting. For the first time, rather than simply say we're going to raise the number from X to Y as of date certain, they're doing a two-step. They said as of July 1, we're going to raise the number from 35 and change to this 43,888. Again, a lot of these numbers, I'm not going to read them. You'll get the deck after the presentation. So all of this will be in black and white and red. But also, so as of January 1, we're going to raise the threshold to 43. We're going to raise that highly compensated up to 132. But really, the second phase of this, phase 2, which takes effect January 1, 2025, is a significant, an even more significant increase. It raises that weekly number to 1,128 a week, or almost 58,600, almost 60,000 a year. Highly compensated goes up to over 150. And I want to just pause for a second and let that sink in. What does this mean as of January 1, when this rule is fully in effect? Well, it means the threshold has been increased almost 70%. And now, no matter where you work in the country, no matter what your duties are, if you're making less than that, roughly $60,000, you are going to be a non-exempt employee, which means you have to track your time. They're eligible for overtime, minimum wage, all of those things. And sitting where Alex and I sit in Washington, you'd say, well, $60,000, that's not so much money these days. But if you are, an assistant manager in, rural Florida or, northern Maine, $60,000 is not an insignificant sum. So the fact that we may now have a situation where the same worker doing the same job in two different places, one might be exempt, one might be non-exempt because the salaries don't necessarily match up, is definitely a real concern. Other things included in the final rule, again, this automatic escalator that, starting in July of 2027, it'll be increased every 3 years based on using the same formula. Again, they include that 10% bonus provision. The final rule did not change. There were some things, I'm not going to dwell on them. They proposed changing the rules in some of the U.S. territories and things of that sort, the motion picture industry. Those were proposed, but they ultimately were not incorporated in the final rule. Parenthetically, I know someone asked in the questions, and I think I answered directly, but for everyone's benefit, someone said, does this apply to employees who work overseas? We have expatriate employees. And the short answer on the Department of Labor's own website is that no. The Fair Labor Standards Act does, except for certain U.S. territories, Guam, the Virgin Islands, those things. But even if you are a U.S. company, if you have U.S. employees working abroad, these rules, this FLSA protection is not eligible. So just something that came up in questions I thought would be useful. How did the department pick these two salaries? Well, phase 1, again, something we're very familiar with, that 20% 2004, 2019 methodology. I think there's a little bit of strategy there, and we'll talk about that. Because when we go to January 1, they raise it from that 20% up to 35%. And now you'll recall that in 2016, a court said, moving it to 40% is too high. That screens out too many people. Well, in my mind, 35 is a lot closer to 40 than it is to 20. So we'll see if that happens. We're going to talk about challenges that are facing the rule. But I also think, because the department did also include a severability clause, that they are, the idea being, we'll do phase 1. If ultimately the rule is challenged, if phase 1's upheld, phase 2 gets struck down, or phase 2 and the escalator gets struck down, at least they can say, well, we got to phase 1 and, we accomplished something here. They gave their reasons for doing it. They sort of nodded, the department did, to this historical screening function. But they also talked about, how key provisions of the rule giving workers more pay, overtime pay, or valuable time back with their family, which I think is the department's way of saying, if suddenly you are now a non-exempt employee eligible for overtime, your employer may be cutting back on your hours to make sure you don't work more than 40. And I put that up there. I think it's a salutary goal. I think most of us would say it's good to give people more time with their families. We're all good people. That's a nice thing. I don't know that that's what the Secretary of Labor was charged with Congress to consider in implementing the statute. So we'll see. We'll see insofar as, what the department relied on, the calculus it used, all that will come into question with respect to, the challenge. As I said, I mentioned there's a severability clause, so that if part of the law gets struck down, the challenges have been filed. I'm going to talk about those next. The entire rule could be struck down, or parts of it could be struck down. Plainly, the department's intent is that if one part of it or two parts of it are stricken, a third part holds. Finally, and I'm going to touch on this quickly because it's a lot of math, but it's in your slides. People often ask about the bonuses. There's that 10%. You can use up to 10% of the minimum salary can be satisfied by non-discretionary bonuses and commissions. So not things like a performance bonus where the manager decides yes or no, but a production bonus, a target. And the important thing to note there is two. One, even if you're going to avail yourself of that 10%, the employee still needs to be making 90% of the minimum on a weekly basis. So I've had clients say, hey, Jim, can I pay them down here? Let's see where we are in November. And if I have to, I can, sort of true them up and compensate them back up to the right level. The answer is no. You can't hold it all until the end. To be eligible for the bonus, using that 10% of bonus, you still have to be paying them at least 90% of the minimum salary on a weekly basis. And there's a nice little calculation on the slide there that comes directly from the Department of Labor's website. So we're going to take it at face value. So as you look at this, if you are someone who is thinking of using the bonuses and commissions to satisfy, this is one where I strongly advise you do so with counsel in mind. Talk to legal counsel, because this, wage and hour law on this, on the substance, when you get really down into the weeds, can get very, very tricky very, very quickly. And the penalties for misclassification or mispayment, and particularly when you're dealing with a significant number of employees, can get pretty steep pretty fast. So if you're in an industry, or if you think bonuses are going to be something you're looking at, you're really going to want to talk to counsel and make sure you're structuring that correctly. Finally, before I flip it back to Alex, and again, I have the pleasure of saying it's always nice when your slides are out of date by the time the program runs. There has been several challenges now filed to the rule. Filed in May 22nd was a challenge brought by a lot of the same business groups who challenged the rule successfully back in 2016. Again, represented by Littler Mendelson. And not surprisingly, a lot of the arguments that we expect to make will be similar to what we made in 16, which is by setting that number so high, you're effectively reading out the duties test. You're making salary the single indicator. Similarly, in 2016, the court said, this is an unlawful rule, so the automatic index provisioning is unlawful. I think there's a strong argument that the way the statute is written, an automatic pilot escalator is not lawful within the confines of the FLSA, so we'll be looking at that. Additionally, and we've seen at least two other challenges have been filed, one by the state of Texas, one by another group in the Northern District of Texas. But there is an argument out there, and I just flagged this because it's pending on appeal right now. It's not related directly to this new rule, but back, you remember in 2019, when the Trump administration raised it from 24 to 35, there was a challenge filed that said, we do not think the secretary has authority to consider any salary level, that really this FLSA speaks only of the duties test, and setting any salary, even if it's that historically low level, the fact that you've done it for years doesn't make it okay. That case is still pending. It was briefed at the beginning of May. We're waiting to see what the Fifth Circuit does. Plainly, if the Fifth Circuit comes down and says there is no room for any salary test, I think that'll be the death knell for this rule, at least in the short term. But all that's out there. Finally, I should note the state of Texas has gone and asked for a temporary restraining order and then a preliminary injunction. An expedited schedule was set, just entered on Friday. The papers will be filed in the next week or so, with an argument to be held on 2 weeks from today, on the 24th of June. I think very plainly the court is trying to leave itself time that if it feels that this rule is not going to be sustained in the long run, to stop it from going forward before it becomes effective on July 1st. I can't guarantee that. I can't even say that's likely, but it is certainly a possibility, and it is certainly much more possible now than it was even just a week ago before those lawsuits were filed. So, going to flip it back to Alex to talk about, since we know there are challenges, we know that deadline's coming, we know people got stuck last time by moving a little too soon. What exactly should we be doing now? Alex, I'm going to give it to you with my favorite ostrich with his head in the sand, and you can tell us all in the next 6 minutes, what should employers be doing right now?
Yeah, of course, we're gonna explain how to do a wage and hour audit in 6 minutes.
6 minutes, give me a highlight.
Yeah, we are short on time, but we will walk through generally what employers should be looking at. I mean, the fundamental thing that employers ought to be doing now is using this as an opportunity to reevaluate those employees within the organization that are considered exempt today and decide whether they will continue to be exempt under the new rule, and if not, what steps to take to correct the situation to match the company's preferences. So the first thing you have to do, obviously, is identify those employees who might be affected by this rule. And that's a relatively simple process. We're just looking for those people who are earning below the new threshold, which coming here in July is going to be $844 a week, about $44,000 a year. For those employees, what you want to be doing is identifying, well, how do I feel about the exemption and the way it's applied today? Do I think that this person is in fact still doing exempt duties as we determined the last time we looked at this position? Do we need this person to be exempt? Is this person working a lot of overtime or hours that would otherwise be considered overtime? Or is this person working 37, 38 hours a week, in which case we may not need to take any drastic action to change this person's status. We'll just go through the process of reclassification as a non-exempt employee. For each one of these people, let's just assume we go through the analysis. I'll try to make this as concrete as possible. We identify one employee. We'll just say that she's working in the accounting department, and we decide, well, her duties are borderline. She exercises some discretion and judgment in deciding how to allocate certain revenues and certain costs, but for the most part, it looks like a lot of what she's doing could be considered bookkeeping, which would not be the kind of duty that has discretion and judgment attached to it. So we're borderline on the duties test. She's earning, we'll say, just under $44,000 a year. So we've got a decision to make on the salary. What do we do with this person? Well, if you decide that we want to keep this person as exempt today, put aside the duties issue, we may need to address that separately, reallocating some of the job tasks. But with the salary, the choices essentially are we reclassify to non-exempt, make this person an hourly employee, don't do anything with overall compensation, just change her salary to be an hourly rate. Do the simple calculation and understand that if this person ends up working more than 40 hours a week, then we're going to have to pay time and a half. Another way you could accomplish a similar result is to figure out how many hours the person is working on average, and then change the compensation base so that you are still expecting the person to work. Let's say she's working on average 43 hours a week. You could, and some employers do this, is reduce the base rate, taking into account the additional overtime the person may earn for those 3 hours, so that overall compensation, or at least your projection, is not changing. But the person is being paid on an hourly basis for the hours that he or she is already working. Third option is just to raise the salary so that this isn't a problem. If the person is earning just under 44 or 43,888 per year, you could bump it up to 44. And then when the new rate kicks in next January, assuming that happens with all the legal complications that Jim just walked through, then you bump it again. And that would be another way to accomplish the same result. And then you walk through the same step with every single employee you have under this rate. You find out who is earning less than the applicable threshold, and you do the analysis. You reevaluate that person's duties. You say, well, is this person exercising discretion and judgment? Is he or she performing duties that require extensive education, training, and application of complex scientific or professional principles, etc. Right? We could walk through all of that. And then you find out how many hours is the person working. How much is it going to cost to bring this person up? What is that going to do for our bottom line? And important, one of the things that people often gloss over is what operational difficulties is this going to put on my business? Is this somebody who I need to call frequently during off hours to jump on some task? Is this person answering a lot of emails remotely? Is this person in a position that's very hard to track his or her hours, in which case that can inform your decision about whether to raise the salary or to reclassify the person as non-exempt. And this last slide we have here, which I'm not sure I've actually updated the slides on the presentation. Let me push this. Oops. You're seeing my technical know-how in real time. Here we go. So this is a good opportunity, regardless of whether somebody is at or near or just under the salary level, to do a full re-evaluation of your position. You don't have to just look at the people earning near the threshold. You can look at everybody. You can do a full exemption audit. Reach out to Littler Mendelson. We have a lot of people with great expertise in this, and figure out how is my exemption hygiene looking today. When was the last time I actually evaluated these positions? Was it in 2010? They've probably changed since then. And this is a good excuse to do it, if you're going to be doing it anyway. Last thing you're going to want to do, be very careful about you communicate the changes. Some people, the Department of Labor being in this camp, think that being reclassified as being eligible for overtime is an unmitigated good thing. Not all employees see it that way. There is some sensitivity around status. There is some sensitivity around having to quote unquote punch the clock. So work closely with your HR department, work closely with counsel, and be very sensitive about how you communicate to people if their status is changing. But we are at time, so I'm going to stop talking. Stephanie, do you want to take it back over?
Yeah, you bet. Jim and Alex, thank you both so much for today's webinar content. We really appreciate it. Everyone who is attending today will receive a copy of the recording and the slide deck, so do not worry if you want to review this content. It will become available for you. And I have just sent out another poll, so if you're interested in learning more about the Navigator OT solution, it does have the new overtime qualifications in the tool. They'll be there in advance of the July 1st deadline. So we are ready to support our clients with this change so that everyone can continue to remain compliant. But again, we thank you all for your time today, and I hope that everyone has a great rest of your afternoon.